Welcome. This is the first in a series of short discussions about tech contracting topics put on by Tech Contracts Academy. Today's topic, intellectual property terms in technology contracts. First, a little bit of housekeeping. We're planning to go about 20 minutes. We've got some questions for our presenter, but we welcome yours also. Please put them in the comments. And this is not legal advice. While David and I are both attorneys, this is not legal advice. That does not create an attorney-client relationship. It's a public conversation, as you know, since you've logged in. So with that, some introductions. I'm Kathy O'Sullivan. I'm here with my colleague, David Tolan, our presenter.
Hello, everyone.
David's the founder of Tech Contracts Academy, in which he teaches about technology contracts to companies through in-house programs, through public webinars, and through new masterclasses starting in October. He's also the author of the Tech Contracts Handbook, published by the American Bar Association. And with that, Dave, why don't we start our program?
Okay, fantastic. Looking forward to talking with you. I can't remember if you mentioned, but if you do have questions while we're talking, don't hesitate to put them in the comments and we will watch for them and work them in wherever we can.
Great, thanks, Dave. First, just to set the stage for everyone, why don't we explore basically what is intellectual property in relation to tech contracts specifically?
So there's often a lot of confusion over the role of intellectual property in IT contracts, and while it's not our main topic, it's worth getting some basics down. It used to be called the field of work, particularly in law firms involving technology contracts, used to be called the IP licensing group. At least a lot of firms use names like the intellectual property licensing group. And it actually leads to it's a bit misleading to describe technology related contracts in that way, because while intellectual property plays an important role, it's not everything. These are commercial contracts. They're contracts that have the same issues about warranties and indemnities and interpretation of contract terms as contracts for any other products and services. So essentially, we're talking about commercial contracts. So what is the role of intellectual property? Why is intellectual property important? Well, the fundamental transaction in this field used to be on-premise software licensing. We have more options nowadays, but that's why you sort of look at this as primarily an intellectual property contract. It was all about IP licensing. So intellectual property licensing is where you provide a license to on-premise software and you need to give a grant of copyright rights so that the customer can use the software. Simply it gives the customer the right to reproduce, distribute, etc., the software. Beyond that, the other two main forms of technology contracts, the fundamental grant, what I call the prime clause in my books, it actually isn't an intellectual property clause. It's a promise to provide, for instance, cloud services, software as a service, or professional services. It's a simple promise. So the role of intellectual property as the center of the contract is most prominent in on-premise licensing. In all of these contracts, though, you also have to worry about what happens if there's an IP problem with the vendor's product or service, if the customer gets blocked from using it as a result of an intellectual property claim. This infringes someone's patent. This infringes somebody's copyright. And so that's why you have a lot of other focus on IP, like warranty terms, indemnity terms, terms about what happens if such a problem, such a claim comes up. So that's sort of the two fundamental areas where IP comes up. One is in the grant of an on-premise license, and two, in all these contracts on the terms addressing what happens if we run into IP problems.
That's great, thank you. So with that in mind, we all know that the technology has changed dramatically in the last several decades. Has that changed the role of intellectual property in the contracts and technology contracts? And if so, how would you say it's changed that role?
Yeah, so this is really helpful information, particularly if you were sort of trained in the old days to understand what that fundamental change is. So until the 1990s, as I said, it was on-premise software that this field was all about. And it's a deal where the customer is getting a copy of the vendor's software and so needed that IP license. The other kind of typical tech-related contract was professional services. And that's simple enough. People, you're buying help from an individual. Someone's going to do some programming for you, or tech support, or consulting, or whatever it might be. So cloud computing raised a new set of issues. And it's really important not to confuse cloud services with either professional services or on-premise software, because it has very different intellectual property implications. In cloud services like software as a service, best example, most common example, the vendor hosts its own technology and does not provide copies of the software that it runs to the customer. The customer accesses that software remotely. The implication is there doesn't need to be a copyright license the way there does for on-premise software. You could say that there's an implied patent license if the vendor has a patent on its software. There's an implied license. It really doesn't have to be spelled out. There's an implied license under that patent. But basically, what's happened with the switch from mostly on-premise software to all this hosted technology, hosted by the vendor, cloud services, is, as I said, intellectual property has fallen out of the center. And this is really important because one of the most common mistakes that vendors of cloud services make is to grant an IP license where they should not. The vendors of software as a service, platform as a service, infrastructure as a service, any form of cloud services aren't giving copies of their software or other technology. They're not giving direct access to it to their customers, so they should not grant a license. So all of these licenses you see in like software as a service contract, hereby grant you a license to use the software during the term, that's actually a mistake. And there's some troubling implications for the vendor for doing that. And there's a real easy fix. Just use the word subscription or some word other than license. It doesn't imply that there's a grant of intellectual property rights. It's like a magazine subscription. It's access. During the subscription term, customer may use the software as a service, period. In fact, I go further when I'm representing those vendors and say, in fact, there is no intellectual property license granted. There is no copyright license granted, to make it really clear.
That's great. Thank you. Where specifically in contracts should we as practitioners be looking for language related to intellectual property that's relevant?
Yeah, so there's, as I mentioned at the start, there's two sets of general locations where you look at and think about intellectual property. There's the prime clause, which is the fundamental promise. And as I mentioned, in an on-premise software license, that's a copyright license. And in a promise of cloud services or professional services, it isn't. It's just a promise to provide services. But then where else does it come up? It's important to understand what you're looking for. In most of these contracts, there's an intellectual property warranty. That's actually growing a little bit less common than it once was with cloud services. Some cloud services vendors argue that we don't need one, and I'll come back to that. There is the IP indemnity, which is where the vendor promises that if the customer gets sued for IP infringement, the vendor will defend and pay judgments and settlements. Sometimes you see that go the other way, by the way. There's some cloud relationships where the customer is providing intellectual property, like content. The customer is, for instance, giving the vendor content that goes on vendors' computers, like stuff that's posted in a chat room or on a website or something like that the vendor is running. And sometimes the vendor wants that indemnity from the customer. So those are fundamental spots where you see it. And then you also see a lot of terms in technology contracts that address things like feedback. So feedback is usually it's where the vendor is asking for a right to either own or a license to or some kind of control over intellectual property that might exist in the ideas that the customer gives the vendor about the vendor's own products and services. So you see feedback terms, and those are IP terms. Sometimes you see trademark licenses where one or the other gives its partner the right to use its mark, hopefully in limited settings. Those are the fundamental places where these terms come up. The other sort of worry area is open source software, and you see intellectual property issues and concerns come up very frequently related to open source software.
So just from that, could you help us understand what you mean by open source software?
Yeah, absolutely. So open source software is actually a much misunderstood and actually unfairly maligned concept. Open source software is software that is licensed under particular terms. There's nothing about the software itself that makes it open source. It's provided, this is on-premise software. It's provided under a license that essentially says the licensee can do anything that it wants with the software, can modify it, integrate it into its own systems, and automatically under this license gets the software's source code. So it's not just the machine operating code, it's the version of the code that a human can read. The source code is really sort of the core of the open source license. It really changes the nature of your use of software if you can get the code. It makes it easier to modify, understand, etc. The concerns about open source software, really there's two. One is some worry that open source software is going to be less secure because the code is out there, because the source code is out there and hackers and other ill-doers could read it and find vulnerabilities. The technical people tell me that that's relatively far-fetched. The larger concern is back to our topic, intellectual property. Copyleft open source licenses, a particular type of open source licenses, often called viral, say that if you do use the open source software you receive under the license and redistribute it, you have to redistribute under the open source license. You have to give the same rights to source code, etc. And the sort of trick is it goes further. This is why it's often called viral, although that's not really fair. If you redistribute the open source software and integrate it into your own product, you're supposed to distribute your own product now as open source software. And software developers of on-premise software worry that means all of a sudden, some engineer sneaks some open source code into their product. Now, all of a sudden, they have to distribute their maybe multi-million-dollar product that they never wanted to be open source as open source software, and they worry that it's a disaster. The truth is, and maybe this is one of the most important things I think we can learn here, is that's actually really far-fetched. The idea that a court would order you to distribute your existing product as open source software when you don't want to, it's never happened before. And I think it's very unlikely ever to happen. If it turns out that you've got code in your product that you don't want to be open source, and you get into a lawsuit over that, maybe by the author of that code, and you lose, the court's going to order you to stop distributing your product and get that open source software out of it. But it's not going to say, well, now your whole thing is open source. That's not how copyright law works. And these are copyright licenses. The open source licenses aren't really contracts. And that is a subject, why not, is a subject for another day. It's long and complicated. Long story short, it's a real concern that you might get blocked from distributing your product because of open source software in it. But it's not really true that you're going to lose the right to distribute your product the way you want. At least it's extremely unlikely, and it's never happened.
Is it fair to say that the open source issue is irrelevant when you're dealing with cloud contracts as opposed to on-premise?
It's largely irrelevant. So the ones that need to worry about copyleft software are the ones who are going to redistribute. That obligation to redistribute whatever you've got under the open source model comes along with on-premise software. You're redistributing on-premise software. It comes along when you make a copy and distribute it. Well, remember what I said earlier, cloud vendors don't do that. They don't redistribute their software. They run it themselves. So all of these concerns, which I've already said are kind of overblown. If all you're doing is running an application on your computers, your own computers, and making it available to your customers as, say, software as a service, even that can't happen. You're not distributing, so copyleft is irrelevant to you. There's one small caveat. The Affero open source licenses, like the AGPL, the Affero General Public License, is a special sort of super restrictive type of copyleft licenses. They say you can't even provide your technology that includes the open source software as a service without giving source code and rights to reproduce and distribute and everything. So if you've got AGPL or other Affero licensed code in your product, then you might have a problem. Again, I don't think you're going to lose control of your product and be forced to treat it as open source software. Your worry is really that you get ordered to stop providing your product, you get blocked, and then you got to fix this problem, possibly at great expense. The good news, though, is very little software is actually licensed under the AGPL or one of the other Affero open source licenses. It's relatively rare.
So I know we could talk about that probably for hours, and I know you've got an appendix on it in the Tech Contracts Handbook. Yes. But keeping an eye on the clock, I thought we'd try to jump to one more topic that I know is near and dear to every practitioner's heart: data.
Yeah, and actually, before we dive into data, I just want to let's do one thing. Just want to make sure everybody knows that all of these topics we cover in much more detail in the series of master classes that we're about to launch. I teach extensive master classes. This is a series of 4 classes running roughly 2 hours each. And we go into all this and much more. It covers all the terms of technology contracts. So throwing in a bit of a shameless plug there, the first set of 4 master classes begins in October. Then we have another one running through November and another one starting in January. And you get a certificate and et cetera. Anyway, you can learn more about that on techcontracts.com. So that's the plug for a hopefully central place to learn more about all of this stuff and a lot more. So, okay, sorry, let's dive into the next question.
No, not at all. So Dave, is data intellectual property?
Yeah, really good question. So data has become much more of an issue with that transition that I mentioned, going from the vendor's product always being on premise to on the customer's computers to the vendor's product on its own computers, because now the data running through the software is on the vendor's computers, not the customer's. So that's the reason we have all this privacy concern in the last couple of decades. So there's a lot of confusion about the nature of data. And the way I think would be helpful for you to look at it is this, is there may be assets within the data that there can be IP rights in, that the data running through the vendor's software. There may be parts of it that you can meaningfully say the customer owns as intellectual property. There may be copyrightable stuff in there or stuff that's actually already subject to copyright. There may be trade secrets in there. But data itself, it's not really helpful to look at it in terms of intellectual property. Little known fact, much misunderstood. You can't own information. You can't own knowledge. Trade secret is a sort of limited ability to block others from illegally getting at your knowledge doesn't really mean you own your knowledge. And so the bulk of the data that the customer has running through the vendor's systems, say in a software as a service relationship, it's just not meaningful to say the customer owns it. You can say the customer owns it and owns all intellectual property rights in the data, but that actually doesn't necessarily keep the vendor from, say, mining it or looking at it or sharing it even, because there may be no meaningful copyright. And so what we like to do in these contracts when we're representing the customer is we do put in terms that say the customer owns the data and all intellectual property rights in the data, whatever they may be. And we go even further. And you can, by the way, see this language and copy it at our site, techcontracts.com. There's a clauses archive on the website. You can go get this all for free. And it's in my book also. We say that the data represents a compilation under copyright law, which is a way of making a sort of not very strong, but better than nothing claim that the whole set of data the customer provides is subject to copyright. But because we know that's not very strong, that might not be of great value, we then, once we've established that the customer owns the data, we go to what's actually much more important. Because data isn't really very protectable with IP, we put in contract terms to protect it. And that's where the bulk of the language in a tech contract dealing with data should be. It's restrictions on what the vendor can do with it. You might not have IP rights that say, you can't touch our data, you can't mess with our data, even if you say you own it. But you can say that in the contract. You say literally, vendor shall not use the data for any purpose other than to provide the services. Or maybe there's some exceptions related to aggregate data, stuff like that. But the important thing in a contract for the customer is not to focus on IP, say it's yours, say it's your IP, but then focus on contract terms that address data rather than relying on IP.
And so having different contract terms than what you just have for the IP.
That's right. You start out with the IP statements. Customer owns all right, title, and interest in and to the data, including without limitation intellectual property rights. Then you go through some of that other language I mentioned, saying that the data is a compilation under contract law and is valuable property. And as I said, you can get all that language at techcontracts.com. Then you just can't look at yourself as done. You've done all you can in terms of IP, but you may have then 8 paragraphs of data management and control terms, which supplement the weakness of IP by putting in contract terms about data. And again, that language is available in my book, the Tech Contracts Handbook, and it's also available for free on techcontracts.com. You can just go and copy and paste it.
So looking at our clock, I realize we've run a little bit over. Dave, would you like to take a question?
Yeah, looks like there was a question up there. Let's put it up and address it. Yeah, there we go. So the question is, with respect to engaging partners in joint development of software/digital products, on-prem or cloud, what are some thoughts in overcoming challenges in IP sharing? Interesting question. So engaging partners in joint development. Joint development contracts. So this is not a customer to vendor contract. Joint development is 2 companies that are probably vendors sharing in the development of something. And often the instinct is to say, well, we'll just each own an undifferentiated share in whatever intellectual property is created. That can create a mess. What you really need to understand is that joint ownership rules for copyrights and patents actually work differently. And so just without saying more, we're each going to be the joint owner of all IP could mean you have conflicting rights and obligations about the technology that you've created, together. And you really might have a mess on your hands. So in any joint development agreement, I recommend you go much further than just saying that intellectual property rights will be shared. You really want to go further and say that and define what each party can do with the technology that's created. In other words, if one puts the technology in its product, is there a royalty owed to the other? If one wants to sell its interest, to assign out its interest to a third party in the technology, is there some kind of consent required from the other? You want to have your contract very thoroughly define what you're going to do. You also, by the way, might define areas that one will own exclusively of the other. Maybe all the technology that achieves X, Y, and Z, partner A will own, and all the technology that achieves A, B, and C, partner B will own. Of course, you've got to define that very clearly. And then maybe there'll be a license granted from the owner to the other so that there's full-on sharing. But again, look at a joint development agreement as something where you don't rely on intellectual property law to define what's going to happen with joint ownership, where you really do a very thorough job of having the contract define how the technology is going to be shared. Well, it looks like we're at time. You know, as Kathy said, this is, or as she may have said, this is the first time we've done one of these LinkedIn Live broadcasts. We'd love to get your comments on how it went and what's useful. This will probably be an evolving program for us. So we'll be doing this again, I think usually in this sort of short format. So we're eager to interact with you more. And again, as I said, we also offer these master classes, a very full and thorough education on all of these topics. You can get information about signing up for them and getting certificates for them and everything at our website, techcontracts.com. So please don't hesitate to put in comments. Also be aware we're going to post the video of this recording so you can come back and listen to it again. Whatever your thoughts are, we would love to hear from you. And thank you for coming.
Thank you.
If you found this video useful, please come check out Tech Contracts Academy. We provide training on drafting and negotiating contracts about artificial intelligence, cloud computing, and other forms of software. It's all for lawyers, contract managers, and any business people involved with contracts. So please come check out our programs live and on demand at techcontracts.com.